About efforts to achieve accountability and reparations for immigrants who are hurt by the US government using the Federal Tort Claims Act, or FTCA. We'll be talking a little bit about the history of LCCRSF's FTCA work and the current push to harness the FTCA to secure reparations for families who were separated at the border during the family separation policy of 2018. I'm Bree Bernwanger, a senior attorney in the Immigrant Justice Program at the Lawyers Committee for Civil Rights of the San Francisco Bay Area, or LCCRSF. I'll be the moderator today. LCCRSF was formed in 1968 to leverage the legal community in solidarity with the civil rights movement. Every year, over 1,000 pro bono attorneys donate their time to fight alongside our courageous clients. Together, we work to dismantle systems of oppression and racism and build an equitable and just society. We advocate with clients through direct representation, class action lawsuits, and legislative and policy campaigns. I want to give special thanks to all of our members and pro bono volunteers who are joining us today. In particular, thank you to Arnold and Porter and Paul Weiss for anchoring pro bono engagement on behalf of separated families, and to firms like Kecker, Hansen, Munger, and O'Melveny that have taken a significant number of cases on behalf of separated families, making a wide impact possible. We'll drop a full list of firms who have been involved in family separation work in the chat. All of the firms who were just placed in the chat have done tremendous pro bono work on behalf of these families, and we thank them in particular. Before we get going, just a few housekeeping matters. First, this event is being recorded to share afterward, so we welcome folks to keep their cameras on during the event if you're comfortable, or feel free to turn them off. Please also keep yourself muted during the panel and submit questions in the chat. We'll open for questions and answers in the second half of the hour, but we'll just be taking questions from the chat to make things easier. So please drop questions throughout, no need to wait, but know that we won't come to them until the second half of the hour. Now I'd like to introduce our wonderful panelists. First, we're joined by Phil Wong, who is the CEO of One Justice. He has worked for well over 20 years in public interest law and civil rights. He received his law degree from Harvard Law School and has served as executive director of the Community Legal Services in East Palo Alto, director of policy and programs right here at the Lawyers Committee for Civil Rights of the San Francisco Bay Area, and is the staff attorney at Bay Area Legal Aid. I'm also delighted to introduce my colleague, Hayden Rodarte. Hayden is the Justice Catalyst Fellow with LCCRSF's Immigrant Justice team. At LCCRSF, Hayden has led local and national efforts to seek redress for families harmed by the Trump administration's family separation policies. Hayden also plays a central role in our team's impact litigation, challenging conditions of confinement in immigrant detention facilities. He also works with LCCRSF's pro bono asylum program, where he provides direct representation to asylum seekers in the Bay Area. Hayden received his law degree from Yale Law School. So to open things up, I'd really like to hear from both of you about the types of abusive practices that you've seen in immigration enforcement that hurt people. Bill, why don't we start with you? What did you see that made you start thinking about using the FTCA in immigration work? What were some of the practices from enforcement officials you were seeing, and how did it impact your clients?
Great, I'm happy to start. Thank you for inviting me, and I feel really old being a part of the historical perspective. You know that when you're joining a panel to offer historical perspective, you're old. So putting that aside, let me just start by saying that, there's that saying in the law that no one's above the law and that no one is beneath the law. And I think it's in the immigration system. And when we see the situation of how immigrants are treated, the actual system itself is designed to keep immigration agents above the law, immune from being held accountable for the abusive treatment they have with immigrants. And the system is also designed to see immigrants, or even in some cases, US citizens who are perceived to be immigrants, as somehow beneath the law, undeserving of protections. And that's kind of where this project got started decades ago. The first case of abuse that Lawyers Committee did was about 22 years ago, back in 1999. And it was actually a case of a US citizen who was of Nigerian heritage, who had come to San Francisco airport from an international flight, had presented her passport of US citizenship, and the immigration agent refused to believe that she was actually a US citizen, because in his perspective, she looked like one of those Nigerians, and had shackled her to a chair for hours and subjected her to humiliating treatment. And, that case was like other cases that we heard about that, I think if you're in the immigrant community or work with immigrant communities, there are stories of people being mistreated. It's all too common, but it wasn't really a part of the public discourse back then. I mean, there were stories of immigration agents who would coerce asylum seekers to leave the country without being allowed the opportunity to apply for asylum, or cases of immigration agents deporting immigrants, in some cases even US citizens who had a right to be in this country. There are all too many common stories back then of immigration agents who would humiliate and degrade immigrants. Strip searches were really common of immigrants in detention. You heard stories of immigrants being denied access to their medications or medical treatment. Immigrants sometimes even being denied access to a lawyer. And then one of the cases that we did was, when immigration raids would occur, you would hear of all kinds of abusive tactics used during raids, including a situation where there was a US citizen child who was taken into custody by immigration officials as part of a raid. And that's really what prompted the launch of these cases back then, over 2 decades ago, was that back then there were very few advocates who were actually filing any kind of claims for damages on behalf of individuals who had been mistreated. And so in the decade that followed, Lawyers Committee actually ended up filing about a dozen of these cases in all parts of the country. And once again, the goal was to ensure that immigration agents were not above the law, to actually hold them accountable for the abusive treatment. And probably for me, even more importantly, just ensuring that the stories would be told, that clients could tell their truth, and that clients received justice in their cases. And in total, I believe those cases brought in about over $500,000 settlements in terms of the outcomes of those cases. And just as important to me was that over those years, as the cases got a lot more attention, more advocates across the country started filing these claims, and they became much more, it helped elevate the stories into the public discourse, public awareness of what was going on, and ensuring accountability.
So Hayden, I'd love to shift to you and hear some of your perspective. You joined the Lawyers Committee just a couple of years ago in the midst of the Trump administration, an administration that was, I think, pretty explicitly telling asylum seekers in particular that they were below the law, as Phil articulated. Can you talk a little bit about some of the types of abuses that you've heard from your clients about, and sort of how you've seen the system work to abuse your clients?
Thank you, Bree. And I think that Phil's framing for who is above and who is below the law in the eyes of the law is an extremely important and grounding framing for until the work that we continue to do with our clients at LCCR. So we came recently to assessing abuses and forms of reparations and pathways to forms of monetary compensation for our direct services clients through our asylum program when during 2018 and 2019, when families were being released from custody at the border who had been detained and forcibly separated under the Trump administration's family separation policies. Although those policies were called many things, but mostly the zero tolerance policy, in which families, regardless of how they had crossed the border or whether they had presented themselves at a port of entry, they were being treated as though the child had traveled by themselves and was being treated as an unaccompanied child and was taken to put into a different arm of the federal government and thrown on a plane and taken to as far as geographically possible in the United States and forced into a federal contractor or with an adoptive family. And their parents were told many times that they didn't have a claim to seek asylum in the United States and that they would never see their child again. And the only way that they could possibly see their child again would be if they gave up their claim to asylum and returned to their country. And so we saw this story over and over again with a group of families that settled here in the Bay Area. And we saw different iterations of this story very clearly, reflecting what we knew had been happening for over a year at that point, through the news and through our colleagues working at the border and nationally on policies and litigation to stop the separations from happening and to force the government through judicial injunction to rejoin families and to provide families, to make families as whole as possible when it came to their access to asylum and the other forms of humanitarian relief and assistance that they were entitled to. One of the other things that we had seen was that families were being overly prosecuted criminally for immigration law violations, and that was used as a post facto sort of pretext by the Trump administration to separate families, treating parents often as if they were criminals and forcing them through criminal proceedings that were mostly sort of pro forma proceedings as a means of trying to sort of cover their tracks. Since then, there have been a series of reportings from all of the agencies involved, both during the Trump administration and now into the Biden administration, about what happened at every step of the planning of this intentionally harmful policy. And so many of the harms and the frameworks and the tools and the systems that have been at play since the very beginning of the founding of our immigration system, but more particularly what Phil was speaking to, and the abuses that are happening in immigration detention centers, whether those are the ones that we hear about more and see the images of on the news, like ICE and CBP detention facilities, or TSA detention rooms and facilities in airports, are still happening. They're happening at the border. Families are being separated under different laws and under different circumstances. But this was an explicit use of tools that existed at the time, long before the Trump administration, to stop families from seeking asylum, to traumatize them so much that when they were forced back into their countries of origin where they were fleeing persecution, that they would tell their communities there not to come to the United States, and that essentially asylum was dead. So those were the words that we were hearing from our clients, and those were the stories that began to coalesce for us in finding ways to creatively and affirmatively use the reparations system that exists within things like the Federal Tort Claims Act, and assessing other types of reparations claims against federal officials and their contractors as part of the larger immigration enforcement and detention system.
So I think this might be a good segue into talking a little bit more about what the FTCA is and what it does and how it works, and sort of how it fits into a model of advocating for these families. Is that, Hayden, can you walk us through that?
Sure. So the Federal Tort Claims Act, or the FTCA, is an affirmative right that anyone has, regardless of citizenship, regardless of location, to file a claim against the federal employees or the contractors of the federal government that are sort of acting as the government for harms against the claimant, against the individual, that would be cognizable under state tort law. And so it's a two-step process. And it's a process in which you file an administrative claim, which is really a form that's available online or on paper, in which you describe you describe a narrative of what happened to you, the dates and times of what happened to you, and how much money you're seeking. And you file that with the agency, the federal agency that hurt you, or the agencies. And so you have to file that within 2 years of the time that you were hurt or the sort of harm was completed against you. That's difficult in this circumstance because in many cases, you would obviously have to have counsel, be able to read the forms in English and be able to submit those forms in English and sort of do this all on time and know about all of these things. So that administrative complaint stage, that first stage, is often pretty tricky to get right, because it can create many sort of procedural obstacles to actually getting to reparations. And so that second claim, once that's filed, the second step, once the administrative complaint is filed, is you there are a few sort of paths that you can go down. The government can respond to you and say, no, this didn't happen. We deny your claim. And from that point, they send you a formal letter, and in 6 months, you have a deadline by which you have to then sue the US government in district court, or you give up your claim. If the government ignores your claim, then you can file anytime after 6 months in federal court. It's up to you. The ball's in your court, or the government can take your claim based on your administrative claim and try to settle with you and offer you an amount of money to settle your claim, and that's it. What we've been seeing here in the family separation context is the Trump administration was ignoring that first step, the administrative complaint. They were neither denying nor trying to settle the claims, which means is that the power is in the hands of the family after that 6 months, after you filed the first step one to file in court. And that is sort of where the rubber hits the road of the change between the two administrations, and that the Biden administration is acting very differently when it comes to the right to asylum and what had happened to families under the Trump administration. So that is sort of a curious political, where sort of politics and the administration in power can really affect the family's chances at and the amount of reparations that they can ultimately receive.
Phil, I'm really curious to hear from you. I think you were certainly the first to launch this project at LCCRSF, and as you mentioned, you were filing these cases, really before anyone did. I can say from our perspective on our team that I think your project gave us the courage to think that this was possible in the family separation context. And so I'm curious to hear from you. You mentioned getting ultimately around $500,000 in settlements. What kinds of impacts these cases had on your clients? What kinds of impacts you felt like they had on kind of the advocacy work you were doing? And sort of on reflection, some of the lessons learned from harnessing the statute early on in a way that hadn't been done before.
Sure. And I want to say that while I was really proud to be a part of this team, there really was a great team that worked on these cases, both before I got to Lawyers Committee and well after I left Lawyers Committee. I guess I wanted to talk about, I could talk about one of the particular clients that I work with and what I saw in that case. And I'll really say that, like, when I got drawn to this work, there was that element of wanting to kind of take on abusive treatment and certainly ensure accountability. But my point of entry was really just on a much more personal level, like connecting with individuals who were being treated as somehow lesser. I mean, part of it was just my own life experience, like growing up gay at a point in America where other gay people like me were very much beneath the law. Beneath the protection of the Constitution, beneath the protection of laws across the country. And that was what got me, to pursue a career in the law. And so when I would hear these cases, I couldn't just help but feel a sense of like outrage and despair that we were in a country where people were being treated in the ways that they were. One of the clients I really worked with was a woman who had fled Kenya. And in Kenya, like, police had rounded up her family at some point, put plastic bags over her kids' heads, and then forced her and her husband to strip naked in front of the kids and whipped her and her husband in front of her kids. And that is what she was fleeing Kenya. And she thought her life would be saved when she somehow got on a plane, was able to get to San Francisco airport, arrive in the country, and tell the immigration officials that she was terrified of being sent back. And instead, the immigration agents were complaining about, these people, why are you people coming from, here? It was a sense in which you didn't belong here. And she certainly took it as like the color of her skin, like they were basically telling her to go home. And what the agents did was they essentially forced her to leave without allowing her to seek asylum and put her back on a plane back to Kenya. And what she described that as was like, imagine fleeing a burning building, and then you're carried back into that burning building. Like, she felt such despair on that long flight ride back. terrified of what would ever happen to her. She eventually did make it back to the country, fortunately, and we had seen her when she kind of came in for help with an asylum case, and then she just talked about her story. I mean, that she sort of took it for granted that's what happened, but that there wasn't anything that could be done. But that lingered with us, and we explored the case more. We investigated it, and we said we'll go ahead and file a claim and see what happens. Um, you know, the most important thing was that the client was actually able to speak her truth and demand accountability. It was amazing to see her like speak with reporters and feel comfortable sharing what had happened to her, because from her perspective, she just wanted to make sure it didn't happen again to others. Hers was one of the cases where we were able to get a settlement of about $87,500, which actually meant a tremendous amount to her and her family. It really did get a lot of national attention, including a story in the New York Times, got a lot of national publicity about what was happening. What was interesting to see in the aftermath was, did anything really change? Certainly at San Francisco with the immigration agents. And years later, we actually heard an anecdote which suggested that there was much more awareness of the fact that immigration agents could be held accountable, because in those years we filed these claims. People would be served with lawsuits, they would have to go through depositions. And years later, we ended up being referred a case where it was actually an immigration agent who worked at the airport, who had been discriminated at that time by their agency for religious reasons. And so as this CBP agent sort of explained, you know, he was trying to ask around to figure out, where can I get legal help? And he asked his fellow workers at the immigration department. They're like, oh, how about that agency that keeps suing us? So there was clearly some awareness and knowledge that there was actually going to be an accounting mechanism in place, because people had to sit through these depositions, and word of mouth kind of got around. Just as important, that case ended up establishing a legal precedent that was published where you know, I think the thing is, like, judges weren't seeing these kinds of cases, but I think judges had the same kind of reactions we did, which is something horribly wrong had happened. And when the federal government keeps making the argument that there is no remedy for this harm, there's nothing you can do, I just think that the federal judges, not all of them, but, you know, many of the good judges find a way within the law to say there actually is some remedy. You actually do have the right to pursue a lawsuit. And in her case, she was actually able to, you know, make that claim for relief. One other just piece I noted about that case years later is, you know, the federal government tracks all kinds of statistics of what happens with immigration agents. And one of the things that they actually track is how many people arriving from other countries, what happens to their cases. And there's this mechanism where an immigrant who's arriving and stopped can voluntarily withdraw their application the country and leave voluntarily. One of the things that we noted is in the years after this case, the number of volunteers of their own dropped dramatically. That was the mechanism they had used with her to try to get her to leave the country, was to claim that she had voluntarily left the country. And so that was great to see. Just one other note in terms of like other kinds of impacts these cases have is two stories. We had this other client from Zimbabwe who similarly, you know, had left the country, you know, was a daughter of an asylum seeker. The agents refused to let her into the country. She was really strip searched, subject to horrible conditions, and sent back. And for her, she was just so outraged that she decided to get into, you know, study law. And there are ways in which what happens and elevating these stories empowers individuals to find ways to like change the system. One other story I just wanted to share was an Egyptian immigrant who right after 9/11 was arrested by these federal agents who assumed he was a terrorist, even though he wasn't, subjected to horrible conditions, put in maximum security prison, denied access to his family, his lawyer, just horrible things that happened to him. And he ended up feeling empowered enough to tell his story, actually told it, you know, to national media at the time, filed a lawsuit. The federal government was trying to deport him. Lawyers Committee really found him pro bono counsel to fight against his deportation. And when we circled back with him years after his case resolved, he was sharing that by then he had become a US citizen because he won his deportation case, went through the naturalization process, became a US citizen. And back then, this was 2008, he was campaigning, he was going to volunteer for a political campaign for Barack Obama, who was running for president, and was going to succeed the president who had subjected to him these kind of conditions. It was going to be his first time voting, and he was just so excited. And for me, that just brought up, there are ways in which the transformative impacts of these cases may not be known for years, but they are real and they are profound.
There's something so gratifying about after a client has been told by an officer of the US government that they don't have rights. It's so gratifying to sort of see them realize that they do and exercise them and really kind of get a foothold and find a place here. I feel like that what you're describing really, really resonates with me and things that we've seen with our recent clients. I am sort of, as we shift into talking about how this works in the family separation context specifically, Hayden, you mentioned there's been a lot of litigation over family separation, right? There's been an injunction that held that the separations themselves were unconstitutional. There have been some reunifications. There's been a lot of advocacy, to get individual families asylum and the ability to remain in the country, which we know is a major point of concern for anyone who's fleeing violence, which is really, all of these families. It's why they were here, sort of as Phil described with his clients. I'm curious, I think something that you said, Phil, made me think about how damages claims fit into sort of the broader scope of advocacy and what coming away from, your decades of doing this work, sort of how you see all of those, all of these advocacy tools working together and how damages claims sort of fit in.
I'll say one thing, but then turn it over to Hayden, which is just that one thing that was unique about the system is that our system is designed, a lot of times people think about injunctive relief and suing the federal government for things that it's doing. And the system is designed to really keep those cases out unless you show that this practice you're suing is really going to happen a lot and in the future. And that was sort of a point of entry for us back then in terms of this was one of the few ways to actually have a case brought to light. But
yeah, I memean, I think I sort of have the same reaction. I think in asylum cases, for example, we so often have to say, our clients will be telling us about things that happen to them at the border or in detention, and we have to shift gears because that's not the type of abuse that the case is meant to resolve, and it just kind of sits there the way you described. So shifting gears into family separation, Hayden, can you talk a little bit about what the FTCA work that Lawyers Committee has done on behalf of separated families has looked like and what some of the goals have been?
Yeah, thank you, Bree. I think, Phil, that sort of thinking about the harm and thinking about the entire system and where the resources are and what the most sort of emergent issues are when a client comes to you and when the client comes through our asylum program, the top of mind need is to protect that person from, or that family from returning to the place where they were being horrifically harmed, where they were fleeing. And then they passed through horrific experience after horrific experience as they were moving through the migration process to come to us. And so direct services organizations and service providers in the Bay Area and in most places in California are focusing on that most emergent need. And there is neither usually the training nor the resources to focus on what have become the everyday harms that have happened to families as they move through those last couple phases that I just mentioned. And so as we were discussing how these cases, the families and the clients and the stories came to us most recently, they have looked like, very similarly to how Phil had mentioned, the client comes to you for asylum relief or another form of protection. And then this is part of their story that, depending on how much the individual wants to sort of describe sort of what happened to them in chronological order, is usually a large chunk of that. And that wasn't something that we nor many service providers had the resources to focus on, and the everyday harms that shouldn't be happening, and the everyday parts of the systems that shouldn't be hurting communities of color, migrating communities. And so the work in representing families has focused on first identifying walking the family through what happened to them from the moment they crossed the border, or from the moment they had an interaction with Border Patrol, until the moment that they were released and they settled in the Bay Area. And so what we had done is we began to speak with some of the council and some of the organizers at the national level who had been litigating the injunctive issues that Bree had mentioned to stop the separations. There was a large class action called the Miss L class, and some related class actions that were stopping the separations and providing families another chance at the asylum system because of the traumas that they had experienced. And we found an enormous need that the council who'd been litigating those cases couldn't meet, was timely filing that first step that we've been discussing and filing an FTCA claim. And because of the state of a few of the only remaining forms of relief against federal agents, such as Bivens claims, the FTCA really became one of the only stable options and possible options for getting families to monetary compensation without having their claims completely dismissed, because the Supreme Court, unfortunately, over the last couple decades, has closed off the Bivens form of claims, which can look often very much like the FTCA, but has just really very terrible conservative case law, barring many individuals from actually getting to relief there, and potentially affecting their ability to simultaneously file an FTCA claim. So we focused on FTCA claims because of the state of the law. And we partnered with another nonprofit, the Asylum Seeker Advocacy Project, which is a bunch of young, fabulous attorneys, many of whom were my friends in law school before they founded this extraordinary organization that focuses on empowering and providing resources to and representing asylum seekers all over the country. They have a remote model, which is quite extraordinary. And because of that, we are able to partner with them and harness our joint pro bono connections. This is nonprofits, this is law school clinics, this is law firms of all shapes and sizes, this is corporations and their legal departments. And we were able to create a robust pro bono network of several hundred attorneys to help us screen families for to help us file the family's claims before their 2-year statute of limitations hit, which was approaching extremely quickly. And so we spent the first 6 or 7 months of 2020, of just last year, making sure these claims got in on time, providing technical assistance and as many resources as we could in real time to the pro bonos who were placing, with whom we were placing these cases. And so we and several other nonprofits around the country screened families for their claims, prepared the cases to be placed very much like we do with our asylum program, with local nonprofit, with local pro bonos. And then we assisted pro bonos throughout the process of making sure those claims were filed as efficiently and as completely as possible, to give that family that chance, because of that administrative complaint, which we called admin complaints, are really the key into that door. And without that, there's just no way. And so it was really an extraordinary effort in which families in rural parts of Central America, which really made up the majority of families that were ultimately affected and forcibly deported back to the places where they were fleeing persecution in Guatemala, El Salvador, and Honduras, were filing these claims from their homes, and were filing these claims from coast to coast. And we had pro bonos working with Indigenous language interpreters, working with us and other Spanish language interpreters to make sure that their stories were being told to providing them as much counsel as we could about the intersections of their immigration cases. If they had immigration cases and they were essentially the U.S. government was aware of them, and speaking truth to power about what had happened to them, because they were filing these complaints with the very agents and the systems of power that harmed them horrifically, and giving them that chance. And that bought them time, in a certain sense, to think about, to see how the tail end of the Trump administration would react to these, and see how the Biden administration would take these on, and to figure out what their next best steps were. So it was really an empowering moment, and it was a storytelling moment, but also a claims preservation moment, because the statute is so very strict about making sure these are filed on time.
So I think one thing that's sort of striking in kind of the difference between, you know, how claims were handled back when Phil was leading the project and now, is that there was this moment in which there actually was one group of people who experienced one harm that was the same, which is like this mass separation. And, you know, along with that, as you mentioned, Hayden, sort of other harms that happened from the minute they were taken into custody to the minute they left. So I'm curious about sort of given this moment in which there are, you know, hundreds and hundreds of families who have simultaneously exercised this right, I think for the first time in this way, what do you see as kind of the short-term goals for the families themselves? And, you know, just kind of a sort of summation of what are the longer-term goals that, you know, your clients have voiced and that advocates have identified to move forward from this project?
That's such a critical question. And it's really what is really our sort of guiding principle here. There have been very few instances in US history in which the federal government has in such a calculated and intentional way harmed a group of people, a specific group of migrating communities coming into the United States. The only other real historical analogs for something that was this broad and this intentional and this well documented were the forcible deportations of Latinx communities out of California to Mexico, even if they were US citizens under President Hoover, and the forced internment of Japanese heritage communities under FDR during World War II. And the claims settlement in the forms of monetary compensation that came out of that latter group. That's really the only analog that we have here. And so this is a truth and reconciliation moment from an advocate's a larger historical perspective, but this is also a chance in which, like in the two prior analogs that I mentioned, families are in many cases risking their safety once again and risking their privacy and their protection in naming what had happened to them, formally filing these complaints with the same agencies who are in power and who purposefully created these policies to harm them specifically, and who have reams of paper specifically about them and everything that they know, who they are, including their claims. And so from many families' perspectives, I can speak for the families that we represent in the FTCA claims, and many of the families, the hundreds of families that we've screened, is that they want to make sure that there is a record of this somewhere, and that they are part of a movement to make sure that the government never makes a policy like this again. They know that this is a form of relief which involves an individual assessment and a sum of money paid to them. However, they are acutely aware of the group effort that this is on behalf of all of the families who we've been able to screen, and sending a very clear message to the administration, both the last administration and this one, that this can never happen again, that this is a product of a centuries-old immigration system, which was founded in racism and xenophobia at the border through the creation, the resurgence of the Ku Klux Klan, and the use of private contractors and individuals who lived at the border to essentially create policies, which have now, unfortunately have developed into federal policies that still live today, that other people and harm them when they are the very individuals who are fleeing some of the most horrible forms of ethnic cleansing, government-based persecution, and persecution by in the domestic sphere, et cetera. And so this is really a movement by families who feel empowered to speak to the very agents that did this to them, and to try to make sure that by having a collective effort that this doesn't happen again ever in this way, and that it's abundantly clear that how very permanent the damage was, and how very unique the damage was, and how there is a very through line from the very people who made these decisions, the agents who executed them, and the families who suffered at the end of the day and continue to suffer. Many of the families are still separated and their harms are still ongoing.
With that in mind, how can community members support this movement and support this work?
So we are at a pivot point. The Biden administration has made several salvos in different ways within its authority to form the Family Reunification Task Force, which is one form of relief in bringing families back together in the United States or in their countries of origin, depending on the family's preference, if they would like to move forward with that. That process is beginning as we speak, and physically reunifying families that were affected by these policies. And as part of that mandate, which still remains slightly unclear from the text of the executive order that established the Reunification Task Force, is what other forms of support, including reparations and payouts to families, are going to be available in sort of the four corners of what that document says and what its sort of mandate is. And then there are the 14 or 15 cases that are now on file, which are the FTCA cases that have matured into district court litigation, in which essentially the first half of the fact section reads the same because it's the same policy that harmed these families, and the rest is a list of some of the most horrific sets of facts you might read as an advocate, in which families were told that their children will be disappeared from them and would be forced into adoption, and that the parents would have to go back to the persecutors, and that they didn't belong in this country, and asylum seekers are the enemies of the United States. And so that is a point that the Biden administration, at least in many of its overtures, is trying to rehabilitate from the past administration and try to make up for in the forms of reforming the asylum system as we know it, and providing other pathways of relief, either through supporting legislation that is currently being passed for reparations and pathways to citizenship for families that were affected, things like temporary protected status, things like using the executive's power to stipulate to asylum, which is something that they technically do, but that Trump threw many obstacles up by creating policies on his way out that tried to close some of those pathways. But working within the White House to put forth ways that families can to minimize the amount of obstacles for families to seek both monetary relief and protection and ultimate status in this country. And so I think that's really the pivot point that we are at historically, and it's something that we are organizing at a national level, LCCR and our main partners ASAP, to put forward as much of the expertise and front and put and make sure that the stories of the families who are affected that wish to share them are at the very forefront of everything that we do, and they are consulted as experts in what happened to them.
Thank you so much, Hayden and Phil, for sharing your experiences and work with us. I'm going to open up to questions now. We have one in the chat. Others, please, if you have questions, feel free to drop them into the chat. So first question is, how about, Hayden, I think you just touched on this a little bit, but what about immigration benefits for harmed families based on having been subject to the separation? What about U visas? And just as context for anyone who might not know, a U visa is a particular type of immigration relief that is available to someone who has been the victim of certain types of crimes and who's assisted law enforcement in the investigation of those crimes. So is that something that's happened?
Yeah, that's a really great area, and is potentially an extremely fruitful area for ultimate relief for families. So there is a history of FTCA claims essentially being a vehicle for forms of permanent relief for families. And that's through doing some of the things that I'd mentioned that the White House and the different agents, the counsel for the different agency, the immigration agencies can make, can add into any settlement agreements. Some of those examples include deciding not to remove a family, deciding to stipulate to certain parts of an asylum claim to make it easier for the family, if their family is in immigration court, to ultimately get asylum and make the immigration judge's job very easy. Includes providing benefits like work authorizations and things which can be adjudicated very easily by the agencies involved, and essentially to fast track the person's path to citizenship in the end, to a green card and citizenship. So that's one thing that's possible. The Trump administration, unfortunately, created many, essentially tried to tie the hands both of itself and any other future administration in actually doing those things. There have been some good cases. There's been one particular good case since the election, which has enjoined some of the previous administration's attempts to cut itself off from providing those forms of relief. And then there are obviously legislative fixes, which is really what we need at the end of the day. But the U visa point is also very, very important. U visas essentially need a signature from a law enforcement person, and in some cases they require, they could take a signature from a state adjudicator, like a state judge or something, which allows you a pathway to citizenship ultimately if you're the victim of violence and you filed a police report or you've taken your claim to a local law enforcement agency. And that's been a very powerful tool for many people over many decades to receive status because they were victims of a crime in the United States and they reported that crime or assisted law enforcement in prosecuting that crime. The Trump administration once again has tried to raise many obstacles for people seeking U visas, and unfortunately U visas have a numerical cap which Congress controls at the end of the day, and so there has been quite a big bottlenecking of U visas being adjudicated to provide someone relief, and essentially cut them off from being deported if they're already in the immigration court system. So that's a fight to continue to be had.
Another question is, how many lawsuits have been filed on family separation FTCA cases through pro bono attorneys? The question is at LCCR, but I think it would be great to kind of talk about the landscape more broadly, Hayden, of litigation, and also of administrative claims, and sort of what LCCRSF's role has been, and sort of where kind of our clients and pro bono communities stand in the field of the FTCA claims that we're aware of.
So we and our main partner, ASAP, the FTCA for Separated Families collaborative that we established in late 2019, assisted families and also ourselves filed over 280 administrative claims, which we now know make up half or more than half of all claims filed worldwide on behalf of separated families. And so what that means is that those families have the chance, they have the key into the door that can get them to ultimately reparations. If the government wishes to try to settle those, create a framework for trying to assess the claims on an individual basis, which is the claimant's right, or to just be silent and then essentially force all the families to try to litigate the claims and sue the government over and over again in every one of those instances all over the country, because they can file where they live. So that's potentially not just all across the board, not all, just all along the border in Arizona and Texas, where the vast majority of families were separated physically, but in all the places where the children were taken to, in all the places where the families now reside. Those are now all potential venues for suit. And federal judges, even just yesterday, are in California, are continually denying motions to dismiss in the government's attempts to say, oh, you know, we have sovereign immunity here, or this was a discretionary thing that we could have done because it was a policy, and you know, how dare you plumb the depths of our immigration policies, and it's sort of our choice what to do. The parents were dangerous, or all of these excuses judges have been over and over again sort of throwing out the door. There are a couple cases in the District of Arizona which are which have advanced the most, and those are sort of the key cases, and those are now in the discovery phase. And so essentially what has happened in those cases is that the government has lost its motions to dismiss in those cases. The judge there, Judge Bolton, is other cases in our filing in Arizona are being related to that case, which is a great sign that several of these groups of families can move forward. And then because those cases have advanced so far into discovery, other judges are sort of looking to those cases, which are now sitting in our circuit, as a template for how to adjudicate some of the, to essentially how to adjudicate the initial pleadings in those cases, which has led to now 14, I think possibly maybe 15 cases now on file, 15 separate cases. And those are cases on behalf of individual families and groups of families. The FTCA really doesn't allow for class actions because of the procedures that we've been talking about are so technical that class actions aren't really possible here, and shouldn't be, because these are individual harms that are happening to people with very specific lasting damages and very specific stories that would be very hard to fit into a class action and possibly not benefit each family who has sort of suffered on different levels and in different ways. But that's sort of the state of that. And LCCR is leading efforts to organize all of the council and the nonprofits who have filed these cases around the country and getting us sort of on the same page about how we should be a unified voice and seeking reparations from the government, and really trying to harness the power that comes with these numbers that we have.
Another kind of follow-up question to this one, to the extent that you are able to say, what kind of indications do you have so far of what the Biden administration's appetite for settling these claims might be?
This is a hard question because both administrations had been quiet for so long. And so what we have seen on the public dockets for some of these cases is the government is beginning to back away from their full-throated checking every possible defense against at the motions to dismiss phase that's possible, and perhaps exercising their privileges in a different way than they did before, or perhaps not taking some of the defenses, or not perhaps making some of the more draconian arguments. The problem with this, though, is that because these cases are being cases are being litigated in many cases by the local U.S. attorney offices, we often see a very strange fracturing of some of the arguments that so there really isn't in many ways a unified voice coming from either administration really about how to sort of defend these claims. It's because these are public cases, these aren't filed under seal like many other types of immigration litigation are. These are extremely public cases, so anyone can pull. I mean, we have a series of toolkits in which we have trackers for all these cases. So you can go up and look into where these cases are, the facts of these cases, how the government is responding to them, and even some of the transcripts of some of the oral argument, and really see the government taking different tacks depending just sort of who is defending these cases. Sometimes they present the executive privilege and say, well, you don't have a right to discover this piece of information. because it's protected. And in other cases, you have the government making very strange venue arguments in some places, claiming that immigrants aren't people and they can't reside anywhere. So it's just, it's really the joint effort on our part is to make sure that advocates are on the same page about our final goal, and to make sure that we remain a unified force against against any form of stonewalling or ignoring by the government of what happened, and paving the path for forms of relief, monetary and otherwise.
Thank you again. Sadly, the hour is already almost up. Thank you so much, Hayden and Phil, for your time and for sharing your expertise. Thank you to everyone who joined for your questions and for being a part of this effort. In particular, huge thank you to the pro bono attorneys who've made this really giant movement possible. I really encourage you to share today's discussion in your communities. If you're moved to donate to fuel the work that LCCRSF is doing on behalf of and alongside these families, please visit our website, lccrsf.org, or make a contribution through the link in the chat. If you would like to volunteer as an attorney or an interpreter, we'll include that information in a follow-up email with today's recording. There's really a whole lot of ways to support these families. One is representing them on FTCA administrative claims, but another is representing them on their asylum claims. All of our clients in the FTCA context are also seeking status here. And a part of the way that FTCA representation is possible is that we're also able to connect people with pro bono asylum representation so that all of their needs are met. We also got a question in the chat about technical assistance on FTCA claims. LCCRSF does offer technical assistance to pro bono attorneys, nonprofit attorneys, really anyone. We do it through our collaboration with ASAP. You can email us at ftca@lccrsf.org for technical assistance. And again, we just really thank all of you for your time, and huge thanks to the pro bono attorneys who've made this possible. Thank you again, Hayden and Phil, and everyone have a great afternoon.